everyone, my name is Sanmati Esrao. I'll be discussing Marbury versus Madison case today. It is a landmark case which established the principle of judicial review, granting federal courts the power to declare legislative and executive acts unconstitutional. The decision iterated by Chief Justice John Marshall is one of the most important cases in the history of American Constitution. The decision rendered judiciary on par with the other two branches of the government. We we are familiar with separation of powers by Montesquieu, where there will be three branches of the government. First will be the legislature, which makes the law, executive, which implements the law, and judiciary, which interprets the law. Let us see how the decision rendered by judiciary made it on par with the other two branches of the government. This will be my content. Let me reiterate by stating that this is a landmark case which held that articles of American Constitution did not provide for judicial review explicitly, but it was implicit in nature. It was more or less about Federalists versus Republicans. The bench consisted of Chief Justice John Marshall, Justices William Cushing, William Patron, Samuel Chase, Bushrod Washington, and Alfred Moore. The case arose during an intense battle between the Federalists and the Democratic Republicans. In the election of 1800, Thomas Jefferson defeated John Adams. In the final days of his presidency, John Adams and the Congress passed the Judiciary Act of 1801, which created new federal courts and judgeship. Adams went on to appoint several midnight judges. In them, one was William Marbury, who was appointed as a Justice of Peace for the District of Columbia. Let me tell you, Marbury's commission was signed by President Adams and sealed by the Secretary of the State, John Marshall. However, the commission was not delivered to Marbury. Later on, Thomas Jefferson became the president. He instructed his new Secretary of the State, Madison, not to deliver the commission, because they believed that the appointments would be an attempt by the Federalists to control judiciary. Later on, Marbury filed a lawsuit directly in the Supreme Court of the country, seeking a writ of mandamus. He based his claim on Section 13 of Judiciary Act of 1789, which granted the Supreme Court the power to issue writ of mandamus in cases falling under its original jurisdiction. We know four kinds of jurisdiction. First is the original jurisdiction, next is the appellate jurisdiction, then comes the pecuniary jurisdiction, and then comes the territorial jurisdiction. Issues. These are the issues. Marbury was appointed as the Secretary of the State as well as commissioned and nominated as Judge of Circuit Judge. So this, if it is compared with the Indian Constitution, where the judges are appointed by collegium, it is quite different. And no two judge can hold two offices simultaneously. No judge can hold two appointments simultaneously and do justice to both. But it was held that Marbury was entitled to the commission because it was signed and sealed and the appointment process was completed. So here it was held that he had a right to commission as the Judiciary Act gave the court powers beyond those outlined in the Constitution, specifically the power to issue writ of mandamus, which the Constitution did not explicitly provide for. So was a writ of mandamus the proper remedy? An independent committee should have been appointed to elect the circuit judges. I'm trying to draw parallels between US and Indian Constitution and judicial process, where the judges are appointed by collegium. Collegium, although is not constitutionally viable, but it is still practiced in India. But in USA, it is the president who decides the nomination and the election of judges as well as Secretary of the State. Then how can one person be elected to two offices simultaneously? That is a question which I had in the entire proceedings or in the entire case. I'll be reiterating on this. And then the judges in India cannot issue prerogative writs against their own court. This can happen in USA. Let me tell you this, Marbury versus Madison limited the federal court's jurisdiction. It cemented the court's status as ultimate interpreter of US Constitution. As iterated before, the job of judiciary is to interpret the law and not to cross the boundaries given to it and get into lawmaking jurisdiction. Then comes the next issue, that is, did the Supreme Court have the right to issue writ of mandamus? So, Chief Justice John Marshall agreed that Marbury had a legal right and the Commission and was entitled to such a remedy. He concluded that the Judiciary Act of 1789, to the extent that it granted the power to the Supreme Court to issue writ of mandamus in original cases, was unconstitutional. According to Marshall, the Constitution did not grant the Supreme Court original jurisdiction in cases like Marbury's. The Constitution only provided the court with original jurisdiction in specific cases, such as disputes between states or foreign ambassadors, not for routine legal disputes. Marshall established the principle of judicial review, meaning that the courts had the authority to review laws and declare them unconstitutional. Certain criticisms. So the 14th Amendment of US Constitution, which provided for equal protection, why did the court not invoke this as a remedy for the differential treatment meted out to Marbury? And this is a classic case of judicial overreach, as reiterated earlier. And then it is a necessary step to ensure that the rule of law and supremacy of the Constitution is upheld. And let me tell you, this was more or less about Federalists versus Republicans. So it was politically motivated. And the critics also argue that judicial review gives unelected judges too much power to override the decisions of elected representatives, undermine democratic principles. So I will like to conclude by stating that Marbury versus Madison was a landmark case which established the principles of judicial review, which granted to federal courts the power to declare legislative and executive acts unconstitutional. It held that Section 13 of the Judiciary Act was unconstitutional and struck down the arbitrariness as well as the ultra-virusness of the act, and it was the ultra-virus the American Constitution itself. So thank you.